May it please the Court. I finished my first point about the 1971 Act and what that tells us about the ambit of the immigration decision referred to in 82.2h. I want to try to stick with the statutory structure and go to the notices regulations, but could I just flag up one point? I think I probably partly answered a question put to me by Sir John Dyson about the practicalities of this sort of process by pointing to the fact that in this case and in many similar cases the tribunal will in any event be looking at a wide range of information about conditions in the country of proposed return for refugee convention, possibly human rights convention purposes, and that in this particular case the tribunal also looked at admissibility. When I come to looking at some cases, I'll draw attention to two decisions of the Court of Appeal which indicate that as far as the Court of Appeal is concerned, when there is an appeal under section 84(1)(g on refugee convention grounds, the tribunal considering an appeal against an immigration decision that a person is to be removed must consider, where it's raised, admissibility and treatment at the border and method and route of return. So that sort of pushes my response on practicability, the essential response being, well, the tribunal is looking at so many of these issues anyway, pushes that a little bit further. But I'm going to try to stick with the statutory scheme for the time being and look at the notices regulations. And the short submission about this is that the notices regulations underline and require that the immigration decision subject to appeal includes a decision that the person is to be removed to a specific identified country or territory, or to specific identified countries or territories in the plural. And the notices regulations are in volume 2, tab 18. And at the top of the page, you'll see that Regulation 1 says that the regulations may be cited as the Immigration Notices Regulations 2003 and shall come into force on the 1st of April 2003. And clearly, as the Court sees, they were made under the relevant provisions of the 2002 Act. The 1st of April 2003 is the same day as the appeal machinery in sections 82 and 84 of the 2002 Act came into force. And I submit that the notices regulations form part of the statutory code of appeal rights, together with sections 82 and 84. And I put this, I hope, on a limited basis. They can properly be read as shedding some light on the purpose and meaning of the primary legislation.
Well, part of the same scheme coming into force on the same day, but I just noticed that the Act, 2002 Act, was passed on the 7th of November 2002, so it's, there's a good few months. It's not too surprising that they were expressed to come into force on the same date, but they weren't made quite at the same time.
No, they weren't made at the same time, although having said that, we've not looked into that point. We don't know when they were initially drafted, for example, or when thought was given.
And what's the authority that they can be admissible to throw light on the meaning of the statute?
Well,
you cited a decision of Mr. Justice Laws, which didn't seem...
Mihari.
But it just assumed that rather than decided it.
Yes, I think that's probably...
Well, I had a look over the short adjournment of one or two cases, and there's a decision of the House of Lords of case of Hanlon and the Law Society, which is 1981 appeal cases, and Lord Lowry derives a series of propositions from various texts, textbooks and so on. And his second proposition is in these terms: regulations made under the Act provide a parliamentary or administrative contemporanea expositio of the Act, but do not decide or control its meaning. To allow this would be to substitute the rulemaking authority for the judges as interpreter and would disregard the possibility that the regulation relied on was misconceived or ultra vires. Lord Hope, in a decision of this court in January of this year, referred to and adopted that. So you say that it sheds some light on. I'm not sure that, and that's a nice, rather vague way of putting it, but I'm not sure that you can really get much from these regulations as an aid to construing the statute, can you?
Shed some light on the purpose of the primary legislation as
It's totally unreal in practice. These regulations are just prepared and put before Parliament, which has, I'm not quite sure what procedures used, but Parliament has no opportunity to amend them. It either has to accept them in full or reject them, and it very, very rarely rejects them. What was it? Was it a positive clearance or a negative? I'm not sure that it appears, but probably appears from the statute, actually.
Yeah. This is 100.
We've probably not got that.
No.
Section 105 and 112.
5 doesn't seem to tell us.
112 is at page 52 of 71.
Yes. Negative resolution.
Yes,
Yes.
I mean, it's. I'm not sure whether Lord Lowry was just speaking of truly contemporaneous. I suppose they are in a real sense, probably fairly contemporaneous.
But these are regulations that were made under a statute which gives the regulation-making power, and they probably tell you a little bit about what the civil servants drafting them wanted to achieve. They don't tell you an awful lot about what Parliament thought it was doing. Lord Lowry put the same point, only in a rather more elegant and lawyer-like fashion. But one knows perfectly well how these things come about.
Yes. Well, we certainly don't suggest that the regulations decide or control the meaning of the primary legislation. We certainly don't put it any higher than that they shed some light on the meaning, given that they were drafted, presumably, on the instructions of the same department that sponsored or originated the primary legislation. But perhaps...
Are they a little, in a sense, slightly against you? Because if it was integral to the immigration decision that you had to identify the country or territory to which it was proposed to remove the person, then it wouldn't have been necessary to say so in the regulations.
Well, on our approach to the construction of the 1971 Act, in particular, paragraph 81C, that in a case where paragraph 81C is the operative provision, one does get that from the primary legislation, and the notices regulations simply underline the content of the immigration decision consistently with what one already finds in the primary legislation, namely that where 81C is operative, the decision maker simply has to consider which country falls within the list in paragraph 81C. So the only point I make at this stage about the notices regulations is that they simply reinforce and underline the meaning of the primary legislation by requiring the decision maker to actually write down that which he must have considered and decided in any event under the primary legislation. But one could look at it from completely the opposite angle. from the starting point that these regulations really tell us very little, if anything, about the meaning of the primary legislation. Suppose one started from that starting point, one would still be faced with the ambit of the ground of appeal in section 84(1)(e). In deciding whether or not the immigration decision referred to in 82(2)(h) was in accordance with the law, whatever the precise status of the regulations, on any conceivable view, in my submission, they do form part of the law. So I would get them in, if I can't get them in through the front door, I would propose to get them in through the back door in that way, as part of the law that the immigration decision has to be in accordance with. Just pausing because I see that some of the members of the court are still writing. But I just, if I may, without perhaps, because I take the point with respect that Lord Mance put to me about Mojave right at the beginning, but Mr. Seddon's drawn my attention, maybe I'll just read it out, to a passage of Miss Justice Law's judgment, where he says its position is analogous to, but not identical with, that of a statutory instrument which may be paid in aid to construe main legislation, where it's clear that the two are intended to form an overall code. I don't think that in such a case the court would have to disregard entirely the statutory instrument on the ground only that it remained open to the Parliament to strike it down, on the ground only that it still remained open to Parliament to strike it down by negative resolution. I mean, granted, the propositions were accepted, perhaps, or assumed rather than reasoned through, but there is a consideration there of the relevance of the negative resolution possibility.
Where were you reading from?
Sorry, this is Mojave. It's,
oh, Mojave, right.
Yeah, this is Mojave. It's 486 B to C. So he's talking about the immigration rules there. So either, in my respectful submission, this is part of one statutory code which can at least illuminate the purpose and supplement the Act. And I don't put it any higher than that. It's supplementing the Act by really drawing the conclusion that the primary legislation scheme requires to be drawn. And secondly, it is in any event part of the law that the immigration decision has to be in accordance with. So I get it in that way. Now, Regulation 4.1, subject to Regulation 6, the decision maker must give written notice to a person of any immigration decision or EEA decision taken in respect of him which is appealable. For these purposes, immigration decision has a definition, and it's on page 2 of 8, about a quarter of the way down. Immigration decision. This is the definition section, Regulation 2, interpretation section. Immigration decision has the same meaning as in section 82, 2 and 3 capital A of the 2002 Act. So written notice has to be given of an immigration decision, that is, an appealable immigration decision under section 82, to continue to address a point made by my Lord Collins earlier on. Reg 4 has no application to decisions by the Secretary of State refusing to grant a Refugee Convention application or a Human Rights Convention application, as they are not immigration decisions under Section 82. Then Regulation 4.2 underlines that the decision maker must give written notice to a person of the relevant grant of leave to enter or remain if as a result of that grant, a right of appeal arises under Section 83(2) of the 2002 Act. Now, a grant of leave to enter or remain is not an immigration decision for the purposes of Section 82. It's a different sort of decision. And one finds out about that in Volume 1, behind tab 8, Section 83. It's page 14 of 71. This section applies where a person has made an asylum claim and A, his claim has been rejected by the Secretary of State, but B, he has been granted leave to enter or remain in the UK for a period exceeding 1 year or for periods exceeding 1 year in aggregate. The person may appeal to the tribunal against the rejection of his asylum claim. So this is not an immigration decision under Section 82. It's a different type of appeal. Specific provision here is made in Regulation 4.2 for written notice of one type of decision refusing an asylum claim, which is not an immigration decision but which has its own separate appeal right. And there's no requirement here in Regulation 4 or in Regulation 5 to provide reasons for the refusal of the asylum claim, because there's no need. Reasons for the refusal of asylum claims are required to be given under the immigration rules. Just for the court to note, it's Rule 336, which is at volume 2, divider 20. So it's just a written notice. And then at Regulation 4.3, there's again a specific provision for written notice of a particular type of asylum decision. Again, it's notice only. So there is a clear distinction being drawn in Regulation 4 between the requirements that apply to immigration decisions and the requirements that apply to a very limited category of asylum applications. Then Regulation 5, the contents of notice, a notice given under Regulation 4.1. A is to include or be accompanied by a statement of the reasons for the decision to which it relates, and B, if it relates to an immigration decision specified in Section 82.2a, G, H, etc. of the 2002 Act, one shall state the country or territory to which it's proposed to remove the person, or, I think there's a typographical error here, 2, may, if it appears to the decision maker that the person to whom the notice is to be given may be removable to more than one country or territory, state any such countries or territories. So, first of all, under Regulation 5.1, only written notices of immigration decisions have to be accompanied by reasons, not written notices of any refugee convention or human rights convention decision. Even the limited categories of refugee convention decisions referred to in Regulation 4.2 and 4.3. And then again, in Regulation 5.1b, only written notice of immigration decisions of a specified type have to be accompanied by a statement of the countries or territories of proposed removals. What I firstly say about that is that Regulation 5.1b requires that these immigration decisions, including Section 82.2h, formally state the countries or territories of removal, so that inevitably the countries or territories of proposed removal must be seen as being part of the immigration decision. And my consequential submission after that is that the purpose of stating the country or territory of removal must first of all be to inform the person from abroad where the immigration officer or Secretary of State proposes to remove him to, and allow him to appeal. Otherwise, why require the countries or territories to be stated as part of the immigration decision, all of which and every part of which is appealable. And I go even further and submit that it's significant that the expression in Regulation 5.1b, country or territory, is lifted straight out of paragraph 8.1c of Schedule 2 to the 1971 Act. And there are other removals enactments that use exactly that same language. And this indicates that the draftsman of the regulations intended to ensure that the immigration decision could be appealed on the basis that the country or territory wasn't authorised by paragraph 8 of the 1971 Act. My next point, and this is attempting to grapple with one of the reasons why the Court of Appeal dismissed the appeal, because the Court of Appeal was of the view that the requirement to state the country or territory of destination was for the very limited purpose of focusing arguments that were connected with the person from abroad's underlying asylum or human rights convention claim. Now, the first flaw in that, in my respectful submission, is that as a matter of black letter law, the requirement to state the country or territory of removal is exclusively connected with written notice of an immigration decision and not of a refugee or human rights convention decision.
Can you clear up a confusion that I'm in? You distinguished, obviously, between immigration decisions under Section 82 and decisions which are covered by Section 83, which are asylum claims. But the Section 83 category of asylum claims is a very limited category.
Yes, yes.
It is only those where there is an existing leave to enter or remain.
Yes.
So the great majority of asylum claims, I would guess, are those where there is no existing leave to enter or remain. And so the right of appeal comes from a different source. And I would assume that it comes from being told that it is proposed to remove you.
I'm sorry.
Being told that it is proposed to remove you. Sorry, I moved that.
Well,
What is the source of the vast, well, it may not be the vast majority, but the majority of appeals in asylum cases, which are not covered, obviously, by Section 83?
yeah.
Must be Section 82.
It's the rather odd way that Section 82 and Section 84 fit together. Section 82 defines a set of decisions that are appealable immigration decisions, which manifestly do not include decisions refusing Refugee Convention or Human Rights Convention claims. They are dealt with separately by the Secretary of State. But then, as I think your ladyship has been driving at, one of the grounds of appeal...
No, I'm just asking, what is the source of the right of appeal for failed asylum seekers who aren't covered by Section 83?
Section 84.
No, it can't be. That doesn't give you a right of appeal. That simply says what grounds. It isn't. It's got to be Section 82.
Ah.
Section 84 simply tells you what grounds you can appeal on.
Yes, no, I'm sorry, I think I was at cross purposes. Yes, Section 82 must be the basis of the right of appeal.
Yes.
But formally, in point of form, the appeal is against one of those immigration decisions, the refusal of leave to enter, or a decision quite commonly, and as in this case, a decision that a person is to be removed from the UK.
Absolutely. That's the only point I'm making.
Yes.
Which is that a lot of asylum cases, those on the other side of the court can probably tell us the proportion, will be covered by rights of appeal under Section 82, to which Regulation 4.1, as opposed to 4.2, will apply.
Well, yes, that's right as far as it goes, but in my respect, the submission, it does remain the case that the right of appeal is in point of form against the immigration decision rather than the separate decision refusing the asylum or refugee convention.
Quite right. Of course, that's clear. But the only point I was making is that there is considerable scope for Regulation 4.1 and 5.1 to apply in cases where asylum is the basis, asylum and or human rights as the basis for the appeal under Section 82. That's it.
Yes. But in my submission, there is a perfectly good reason, though, why the decision, why the requirement to give reasons and state the country of proposed removal relates specifically to the immigration decision, rather than the separate decision to refuse asylum. And that is because there is a separate duty to give reasons for the refusal of refugee convention claims. If one goes to volume 2, divider 20, under the immigration rules, 5 pages in, one gets part 11 of the immigration rules, and paragraph 328 provides all asylum applications will be determined by the Secretary of State in accordance with the Geneva Convention. Every asylum application made by a person at a port or airport in the UK will be referred by the immigration officer for determination by the Secretary of State in accordance with these rules. That separates out the decision-making process in respect of asylum from the decision-making process which results in the immigration officer refusing leave to enter, for example, or deciding to make removal directions. And then, without looking at the detail of that particular process, when one comes to Rule 336, an application which doesn't meet the criteria set out in paragraph 334, that is, for the grant of asylum status, refugee status, that will be refused. Where an application for asylum is refused, the reasons in fact and law should be stated in the decision, and information provided in writing on how to challenge the decision. Hence the importance of making it really clear when one looks at the general machinery for immigration control in sections 1 to 4 of the 1971 Act, that what that does not embrace is the completely separate process by which the Secretary of State considers and determines asylum applications under the immigration rules, giving his reasons where he rejects the claim.
Section 84 is unworkable unless one knows the country of destination.
Absolutely. Well, the question is, though, how one knows the country of destination and how the refugee convention appeal sort of engages with the Secretary of State's decision to remove a person to a particular country. Now, well, let me put my cards on the table about this point. The reasons for refusing an asylum claim are given by the Secretary of State under Rule 336 of the immigration rules. As this court will have seen on countless occasions, those reasons given by the Secretary of State are always very detailed. They always make it clear why, in considerable detail, the Secretary of State believes that return to a particular country or territory would not be incompatible with refugee convention or human rights convention rights. And those reasons given under 336 obviously name the country or territory of proposed removal and give all the Secretary of State's reasons as to why, in his opinion, return there would be safe and compliant with the Convention. Now, it's those detailed reasons in the Secretary of State's decision under Rule 336 in my submission that actually provide the focus for a refugee or human rights convention appeal. The bald statement of a country or territory of return of the kind required by the notices regulations, I mean, obviously, in my respectful submission, would not assist in any meaningful sense the appellant or the tribunal to engage with the substantive merits of the Convention claim and the Secretary of State's refusal. All of that, I mean, the need to have a specified country of removal to focus refugee convention rights arguments on, that's all provided by Rule 336. The distinction drawn in the notices regulations is a distinction between immigration decisions, properly so called, and all the other immigration and all the other types of decisions that might be made to one side. The main distinction made is between the immigration decisions, properly so called, and asylum decisions by the Secretary of State. And we know that the draftsman must have had that distinction in mind because of the specific reference that he makes to a very limited class of asylum decisions in regulations 4.2 and 4.3.
What's the position with regard to refusal on human rights grounds?
Again, those decisions are made by the Secretary of State for the Home Department, not under the immigration rules, but under his policies, the most important of which is called discretionary leave. We can produce the policy if it would be of assistance. To the best of my recollection, it doesn't actually, unlike the immigration rules, doesn't actually contain, I may be wrong, but I don't think it contains an express statement that the Secretary of State will give reasons. But he always does, presumably because, given the importance of the subject matter, he accepts that there's a public law duty to do so. And in that regard, the requirement in the immigration rules at 336 follows a whole line of cases in the Court of Appeal, where the Court of Appeal decided that the importance of the subject matter in refugee convention claims required reasons to be given as a matter of common law. I imagine the same approach is taken in human rights convention claims. But whatever the basis is of the Secretary of State's giving of reasons in a human rights convention case, it's not because his decision is an immigration decision, because those types of decisions are simply not on the list in Section 82. Yeah, Mr. Seddon's reminded me that some sorts of human rights convention cases are actually dealt with under the immigration rules. Article 3, international protection cases. So the same logic would apply to them as refugee convention cases. So it would mainly be Article 8, human rights convention claims that will be dealt with outside the rules. So my response to my submissions about the Court of Appeal approach to the reasons for stating the country or territory of destination is, first of all, that on the face of it, very clearly, the purpose has to be connected with the provision of the immigration decision and not with the provision of the underlying or ancillary refugee convention or human rights decision, because those are dealt with outside of Section 82. But there are also other reasons why the duty to state the territory or country of removal can't be seen as being for the limited purpose of helping refugee convention or human rights convention appeals to be focused on. I've already given the sort of one practical reason why that's the case, which is that the bare statement of the country or territory of return wouldn't really assist. It is the detailed reasons and the arguments that actually focus, the detailed reasons and arguments in the Secretary of State's asylum letter that actually focus the argument in those sorts of cases.
But I mean, the identity of the proposed country is a very important component of the whole thing, because, for obvious reasons, asylum claims have to be judged in the light of a risk of persecution in a particular country. And human rights cases, if it's a question of whether there would be a breach in, not by being deported from this country, but by what the person would actually face in another country, you need to know what that other country is. So to as it were, say, well, there's not much, you don't get much from being told what the country is. You really need all the reasons. I think that's rather overstating it. It is a very essential part of all this, is to know what is the country to which, for asylum and human rights purposes, which country is the proposed country to which the person is to be removed.
Well, Lord, of course. I think maybe my submission about Rule 336, the duty to give reasons when one refuses an asylum claim, maybe was too truncated. If there's a duty to give reasons for the refusal of the asylum claim, in my respectful submission, clearly the first reason that has to be given is that, in the view of the Secretary of State, the person concerned is not at serious risk of persecution in a particular country. So it's intrinsic to the duty to give reasons for the refusal of the asylum claim that the Secretary of State actually identifies and grapples with the specific country outside of which the applicant is, and in respect of which he fears persecution on his return. And that's really, and that plus the detailed reasons is what one really needs and what one really gets in order to focus the refugee convention arguments.
That's why I said that section 84, particularly 1C and 1G, would be unworkable unless you knew what the country of destination was. Doesn't tell you anything about removal directions.
Well, that's right. 84.1G would be unworkable if one didn't have, I would put it slightly differently, it would be unworkable if one didn't have a reasoned decision explaining why one's refugee convention had been rejected.
Yes.
But one gets that.
Yes.
One gets that from para 336. You simply don't need it from the notices regulations, and you wouldn't get it in the format that you need to mount a viable refugee convention appeal, simply from the bald statement in the notices regulations of the territorial country of proposed removal. Looking at it from a sort of different perspective, I mean, the submission of the Secretary of State, which was accepted by the Court of Appeal, is a very ambitious one in my respectful submission, because what it requires this court to accept is that the obligation to state the country or territory of removal in the notices regulations only has a very narrow function, and in fact only exists as an obligation in relation to refugee convention and human rights convention cases. And that's the proposition the Secretary of State has to establish. And in my respectful submission, that is just impossible as a matter of ordinary construction, because the obligation in Regulation 5.1b to state the country or countries of proposed removal manifestly applies to all decisions to refuse leave to enter the UK, whether or not they involve a decision to refuse a refugee convention or human rights convention application at all. The obligation to state the country or territory of proposed removal plainly applies in cases where there is no suggestion of a refugee convention or human rights convention case. It applies across the board. Therefore, draftsman just cannot have intended to require the country or territory of removal to be stated only to provide a focus or peg for refugee convention arguments. Take an immigration decision under section 82(2)(h), as in this case. It might be made by the immigration officer after a decision by the Secretary of State to refuse a refugee convention application, but it might be made in response to an application for leave to enter that has no connection with the refugee convention, but the requirement to state the country or territory of removal exists just the same. So it just cannot be limited in its scope in the way that the Court of Appeal held. And the point goes even a little further, that when the draftsman intended to make different provision for refugee convention applications, he did so expressly. We've already looked at Regulation 4.2. If one looks back at Regulation 5, this is Volume 2, Divider 18, back at the notices regulations. Back at 5.6 and 5.7, 5.6 provides that the notice given under Regulation 4 need not comply with paragraphs 3, 4 and 5, where a right of appeal may only be exercised on the grounds referred to in section 84(1)(b), C or G of the 2002 Act, by virtue of the operation of section 88(4), 88(a)(3), etc., of that Act. And then 7, where notice is given under Regulation 4 and paragraph 6 applies, if the person claims in relation to the immigration decision that, then little b, the decision is unlawful under section 6 of the Human Rights Act, little c, removal of the person would breach the UK's obligation under the Refugee Convention or be in breach of the Human Rights Act, the decision maker must, as soon as practicable, re-serve the notice of decision under Regulation 4, and para 6 of this regulation shall not apply. It's careful drafting which explicitly imposes distinct requirements about decision notices in limited types of Refugee Convention and Human Rights Convention cases, completely excludes the possibility, in my submission, that the draftsman implicitly imposed the requirement in Regulation 5(1)(b) just for purposes connected with Refugee Convention or Human Rights Convention decisions.
Can you just amplify that? Let's just. If you've got a claim that the decision under 7, I don't begin to understand what subparagraph 6 is getting at the moment.
Yeah, no.
But under 7, if a person claims that an immigration decision is contrary to the Race Relations Act, the decision maker must, as soon as practicable, re-serve the notice of decision. That seems a rather funny procedure, but what is the purpose of all this?
I used to know. No, I'm going to
I thought you were telling us it was very significant.
Well, I think you're saying it's significant not so much for what it precisely means, but for the fact that here there's a very carefully, rather complicatedly drafted provision which deals with the human rights and the Refugee Convention, and you're not too concerned to tell us what it actually means.
No, I mean, I did used to know exactly what it meant and how it hung together, and now I realise that that precious knowledge has somehow seeped away, and I'd have to put in a little note explaining it. But it's the structure of it that is the
Is
big
my Lord's point, anyway.
Yeah,
Yes.
absolutely. Now, implicit in everything, in all of these submissions, is an underlying submission by me that for practical and legal purposes, one can't distinguish really between the decision and the decision as it's required to be communicated by the notices regulations. One might conceptually be able to locate the decision in a file note made by an immigration officer or in neurons flicking across an immigration officer's brain or the Secretary of State. But really, for all practical purposes, the decision is that which you get through the notices regulations. There's a very interesting discussion about this proposition in a homelessness case called Ermakov, which is at volume 5, divider 58. I'll give the court the references. It's 309 little a to G and 315 little a to H. And the point made by the Court of Appeal is that, I mean, certainly for the purposes of the Homelessness Acts, where there is a statutory duty to give reasons for a decision, you can't really, for practical and legal purposes, distinguish between the decision and the reasons with which it's communicated. I'll take the court to that if that's of interest, otherwise I just leave it to be considered. Should there be concern about the possibility of a distinction being drawn between the decision and the form in which it's communicated.
Sorry, could you just give us the references again, please? The
Yes,
page reference.
it's 309 little a to little g and 315 little a to little h.
Thank you. I think the key paragraph is between G and H on page 315, isn't it?
Yes, that's absolutely right. Thank you. I think if the court's ready, I'll move on. There are some relevant cases about immigration decisions, which are relied on by the Secretary of State as demonstrating that the view of the Court of Appeal, by and large, has been that an immigration decision to remove is a decision in principle only to remove from the UK, and that's as far as one needs to inquire, and that the immigration decision, the appealable immigration decision, didn't include a decision to remove by way of a particular route or method, because that gave rise to all the, because if one interpreted immigration decision in that broad way, that gave rise to all the practical difficulties that I think every member of the court has referred to, but in particular Sir John Dyson this morning. I think we would have analysed those cases differently, but may no longer need to do so in quite the same way, because there's been a further decision of the Court of Appeal handed down on Friday, which obviously we've drawn attention, the Secretary of State's attention to, called HH Somalia, and that really puts the earlier decisions of the Court of Appeal in a rather different light. So if I may, I'll look at the other decisions through the HH Somalia lens. You have it.
Thank you.
As the court may know, Somalia is one of those countries where historically it's been notoriously difficult to return people to. So I think the last time I looked, the airport in Mogadishu, which is the only airport capable of receiving international flights, was in fact controlled by a number of different clans, each of whom had different runways. Paragraph 1, Lord Justice Sedley says, judgment is the work of all three members of the court, being given in unitary form because the cases to which it relates were selected for hearing by a single court in the hope of giving some general guidance on a number of related issues. Inevitably, some issues have dropped away, others have acquired unanticipated prominence. All, however, have the same backdrop, the enforced return of individuals with no independent right to be or remain in the UK to a war-torn country, Somalia, where their safety is or may be in serious doubt. Then, para 6, removals of illegal entrants continue to be carried out under the powers contained in paras 8 to 10 of Schedule 2 to the Immigration Act 1971. These permit directions to be given to a carrier to remove an illegal entrant to a country in which he is a national or a citizen, a country or territory in which he has obtained a passport or other document of identity, or where he embarked to the UK, or a country or territory to which there is reason to believe he will be admitted. Safety at the point of return or en route to a safe place is not a statutory factor. It arises as an adjectival human rights or humanitarian issue. So that sets the scene. And then the nub of the decision in the the AM and J Somalia cases is at paragraphs 47 to 58. If the court wishes me to read that, of course I will, and it may be more convenient and speedy for the court to read those paragraphs for itself.
The issue is put on in paragraph 5b on the first page, isn't it?
Yes, I'm very grateful, Lord. The issue is stated there. And then finally, paragraph 124 contains the conclusion on the point of principle identified at para 5b. So the context is that in these cases, decisions that a person is to be removed were all made under section 82(2)(h). The ground of appeal, it's fair to point out, was not section 84(1)(e), but section 84(1)(g). But nonetheless, the conclusion is that however one wants to qualify it by the context of the appeal being under 84(1)(g), the conclusion was that where the point of return and any route to the safe haven are known and are ascertainable, these form part of the immigration decision. That conclusion is reached without considering the notices regulations, which of course don't deal with route and method of return, only country of destination. That's the position of the Court of Appeal from a consideration of the 1971 Act, Schedule 2, and Section 82(2)(h). So the position is that, at least where the appeal is under 84(1)(g), decisions about the route and method of return, when known about, are part and parcel of the immigration decision itself, and therefore are appealable.
But again, I mean, that point may be double-edged, because G is very specific, and it's, I think, well, accepted that G offers a different scheme which requires the court to, or the tribunal to, consider what would happen upon removal under removal directions.
Yes. Well, I haven't really made any submissions yet about the breadth of appeal under 84(1)(e), but my response to the point your Lordship just put to me is that it's hard to conceive of an appeal ground broader than the appeal ground at 84(1)(e).
Well, the point on E is that it's focused clearly on the decision, whereas the point on G is that it is focused clearly on the consequences of the decision in relation to removal. So, I mean, that's the point you have to face. But you say that the better solution, if we have a choice at any rate, is to assimilate the two.
Well, it's part of my sort of ongoing response to the issue of practicality, practicability, but also, granted, there is a distinction between the appeal ground in 84(1)(e) and the appeal ground at 84(1)(g. In my respectful submission, it would still be difficult for a tribunal to properly disentangle admissibility at the border from whether the decision is in accordance with the law under 84(1)(e). One of the points that the court may have noticed being made along the way was that the Court of Appeal's earlier decision in GH was by no means as clear as the Secretary of State contended, and by no means clearly excluded from the ambit of an immigration decision, at least in this context, decisions about route and method of return when known. That's the decision in GH. Of course, what the Court of Appeal don't consider is there's been another case, AK, which also distinguished the decision in GH, and I draw attention to that straight away if I can. It's in volume 3 of the authorities bundle at tab 26. And again, it's fair to say it's an appeal under section 84(1)(g). But what was critical, albeit in that context, was the scope of the immigration decision. And the issue is defined by Lord Justice Richards at paragraph 3. There's a prior jurisdictional issue. It concerns the jurisdiction of the tribunal on an appeal under section 82 of the 2002 Act to consider whether an appellant would be refused re-entry by the state authorities to his home country or place of former habitual residence in a case where no removal directions have been set by the Secretary of State. That, as in the Somalia case, involves consideration of the scope of the Court of Appeal's decision in GH. And the relevant passages are paragraph 14, Mr. Ike's submissions on that occasion. He puts at the forefront of his submissions a jurisdictional point, which, if correct, make it unnecessary to consider any of the substantive issues raised by the appellant. He submits that the appeal to the adjudicator was concerned only with the question whether the appellant would be at risk of persecution or of ill treatment, contrary to Article 3, if he were to be removed to the occupied territories. The adjudicator's conclusion there is no risk of persecution or Article 3 ill treatment within the occupied territories was therefore determinative for the appeal. The question whether it would be possible for the appellant to re-enter the occupied territories and the legal consequences if that were not possible didn't arise. Those issues will fall to be addressed if and when the Secretary of State sets removal directions that engage them, and then that will be a judicial review. That all lies in the future. That submission was not accepted between paragraphs 25 and 30. I draw attention in particular to paragraph 13. It's quite difficult to refrain from inviting the court to transpose that reasoning across to the present case.
is the same as H.H. Somalia and is distinguished by Lord
Yeah.
Justice Ricks on the
Yeah.
basis that it's a human rights
Yes.
issue.
What one derives from these two cases is that, at least in a human rights appeal or a refugee convention appeal, the immigration decision, even without reference to the notices regulations, includes decisions about admissibility at the border, which is AK and treatment at the border generally, and it includes decisions about the route and method of return. Now, what I say about that firstly is that whilst that doesn't completely dispose of the practicality arguments that have been raised earlier, it does seriously complicate them because, I ask rhetorically, isn't it very surprising and a very odd use of the appeal tribunal's resources to require the appeal tribunal to consider route and method and admissibility in human rights convention cases, but not to consider admissibility where conceivably at the same time in the same appeal admissibility is raised under the paragraph 81C Roman numeral little 4 heading.
But they are different in principle, aren't they? I mean,
Yes.
The thrust of, as I read it, paragraph 30, Lord Justice Richards is talking about the tribunal having the jurisdiction to determine the safety of a particular route. That's in the context of Article 3. And of course, one sees that's all part and parcel of a consideration of whether there would be a breach of Article 3. But where you don't have any human rights considerations, then this reasoning doesn't apply.
On principle, what I rely on is the ambit of the immigration decision as defined by implication by the 1971 Act and as defined by the notices regulations. Or to put it another way, what I rely on is the way that the notices regulations are part of the law that decisions have to be in accordance with. They're not to fall foul of section 84 1E. My wider argument, because clearly all of you lordships and my lady are concerned about the practicalities and the point or pointlessness of our case. And my point about AK and the Somalia case is that, firstly, there is no reason why a decision to remove a person from the UK by way of directions under Schedule 2 should be construed as a decision in principle simply to remove somebody from the UK. It doesn't have to be looked at in that way, and it wasn't looked at in that way in these cases. And my second broader point is really in terms of practicability. If the tribunal is faced with an argument in a Palestinian case that he won't be admitted over the border and that would be a breach of his Article 3 rights, if one's looking at a practical and streamlined system of immigration control, why on earth can't the tribunal look at probably exactly the same materials, very similar materials, to determine whether or not he's going to be admitted across the border for the purposes of paragraph 81C?
This one-stop shop appeal, which is provided by Section 82, one can see the need for it when one's appealing against a refusal of leave to enter or refusal of entry clearance. Indeed, I think most of them, until one gets down to the decisions that a person is to be removed by way of future directions, which are the 5 you've been focusing on, one might ask why it was necessary to have this two-stage process, firstly a decision and then later directions. Why do you need it at all? Why? I mean, the person is here by definition illegally, aren't they?
Yes.
And I suppose you could simply have had a scheme which went straight to directions, couldn't you? You ought to be removed.
Yes.
So I'm just wondering, what is the statutory purpose in dividing or creating two stages and only providing for an appeal in respect to the first? Because the first doesn't make sense really by itself, does it? A decision a person is to be removed. Well, I suppose it's. I suppose you could say that was a. We're not going to give you any sort of tolerated permission to stay, but if it's to mean anything, there've got to be directions following it.
Yes, absolutely. I mean, in my submission, it is implicit in the 1971 Act that the decision that you make is a decision to give removal directions to a particular country, to any to any carriers, and that decision is about as final as a decision can get, so that all there is left over is simply the giving of removal directions once the appeal has failed to a relevant carrier that fits within the definition. I mean, the contrary argument of the Secretary of State is this much longer drawn-out process of a decision in principle to remove from, without any consideration being required at that stage as to where removal would be to. That further decision, removal to a specified country, being months, perhaps years down the line. It hasn't even taken place in MS's case, and that's clearly, in my respectful submission, not the simple and straightforward scheme envisaged by the 1971 Act, where decision-making only just gets a look in by implication, because the language is simply talking about the giving of removal directions, and then obviously their enforcement. You get a reference to the decision in paragraph 16, then one just has to imply what is the nature of the decision from paragraphs 8 to 10. And as my Lord has just put to me, it's just a simple and straightforward decision that removal directions are going to be given, that can be given under paras 8 to 10. So that once that decision is made, all there is then left to do is the giving of the removal directions, and there may be some sort of small ancillary bits of decision-making that need to be done to actually put that into effect. And the purpose of all of this is to draw a line between the 2002 appeals machinery and that found under previous legislation, where there were very, very limited appeals against removal directions, and to really focus on the distinction between the ambit of the immigration decision and the carrying out of the practical machinery, which is exactly what one would expect a modern appeals machinery to do, to distinguish between the decision-making parts of the operation and the mere administrative parts of the operation. And the idea of it all is that everything that relates to sort of decision-making and exercises of discretion, selection of countries, territories, everything that people have to think about goes into the immigration decision. It's appealed. And then everything to do with the administrative machinery comes later. It's not subject to an appeal because that would clog up the system. Hypothetically, it's subject to a judicial review, but inherent in my approach to the statutory scheme is the suggestion that judicial review will actually lie only very, very rarely against removal directions, because the decisions, the important decisions, will all have been made at a much earlier stage. And if you haven't appealed, it's too late to judicially review. And if you have appealed and lost, again, you won't be able to.
I mean, the previous cases you've been referring to, GHAK,
Yes.
appear to have proceeded on the basis that
the only way in which you could challenge removal to a particular country was if you could challenge the removal directions. They said, well, there may be an exception to that if the particular country is implicit in the previous immigration decision.
Yes.
That was doubly helpful in a way to someone in your client's position. Firstly, you could challenge the country as part of the immigration decision, probably, and I think if it was the removal to a particular country was inherent in the immigration decision, but secondly, you could anyway challenge the removal directions by appeal. Well, now, the question is, which way has Parliament gone? Has it has it decided that, well, it's definitely decided you can't challenge removal directions at all, but has it also decided that you can't challenge, at least by appeal, you have to challenge by judicial review? Has it also decided that if the country is specified in the immigration decision, as it now must be, or at least as it must be associated with because of the regulations, then you can or you can't challenge it or the reasonableness of the decision to identify it as part of the immigration decision. I'm surprised there isn't any help in the travaux preparatoires, if one may call them that, or in any parliamentary statement or in the notes, explanatory notes.
Well, the best I can do in response to that is to take the court to the explanatory notes to the 2002 Act without pretending that they're going to be a magic bullet for either party.
Paragraph 220.
Yes, your ladyship is well before me. It's tab 1, volume 1, divider 9, and it's, as my lady has already said, 219 and 220.
What page is this?
This is, it's volume 1, divider 9, and it's page 35 at the bottom.
Thank you.
And that refers in the middle of the page to section 82, right of appeal general, and it's the two paragraphs really, 219 and 220, which also make some reference to section 120.
I suppose you can get some help out of that, possibly on the basis that it at least doesn't explicitly undermine the idea that the country to which someone's being removed may be part of the immigration decision. But that idea has only been developed really in the human rights field, so one's back perhaps at an old argument.
The idea is that there is to be a clearer package of appeal rights, although whether they are clearer is something that the court will have to consider. But I mean, there's clearly a principle of one right of appeal and all grounds being subsumed within the appeal. Although again, this begs so many questions because of section 120. Section 120 it helps to ensure that all relevant issues are dealt with in one appeal. And then you have the immigration decisions distinguished from the consequential giving of directions to the carrier. And this drives a fundamental proposition that I'm attempting to submit to the court, which is that what the legislation is distinguishing between is all the thought processes and all the decision-making processes, everything that somebody has to turn their mind to, that is within the scope of the immigration decision that's subject to appeal. And that's to be distinguished from the consequential giving of removal directions, which is just really the carrying into effect in a practical way of that. And that's how you achieve the general purposes in that's how you achieve the specific purpose in section 120. And the general purpose of this legislation to streamline, make more efficient, and to enable and require the appeal tribunal to get to the bottom of the issues that are raised. And the issue MS raised in his particular case, he may be right, he may be wrong, was that it was impossible to contemplate that he could be removed to Palestine. And his simple position, ultimately, at the end of the day, is that he should be entitled to raise that as an appeal. Given,
I'm not sure that by classifying it the way you have, you really advance the argument very much, because what constitutes machinery depends upon what the nature of the decision is. If you say the decision is simply that somebody should be removed from the United Kingdom, you could argue that everything else is the machinery that carries that decision into effect. Or you can say, well, actually, the decision is that he should be removed from the United Kingdom to Palestine, and that the machinery is everything that carries that decision into effect. So I think your description or your classification doesn't really shed any light on the problem. The question still remains: how do you define the decision?
No, that's right. Paras 219 and 220 just address the difference between immigration decisions and the consequential giving of removal directions at a very general and abstract level. But what my submission is that that is consistent with our construction of the ambit of the immigration decision in the light of the 1971 Act and in the light of the notices regulations as being a decision that is required by primary legislation and the secondary legislation to grapple with and make a decision about the person's returnability to specific countries because of the explicit requirement in section 82 2H that the decision is to be a decision that is in accordance or under paragraphs 8 to 10 because of everything in paragraphs 8 to 10 and because of the notices regulations. And then one puts all of that together with the breadth of the appeal right in section 84 1E. I mean, even if there was some doubt about the precise ambit of the immigration decision, surely it's impossible to suggest that the decision maker is entitled to completely disregard the question whether or not the person concerned can actually be removed in accordance with the removals machinery in paragraphs 8 to 10. It's only if the decision maker is entitled to completely disregard whether or not paragraphs 8 to 10 apply, or for example, it's only if the decision maker is entitled to completely disregard whether or not paragraph 8.1c applies when he makes a decision in an 8.1c case, that he can then argue that his decision is in accordance with the law, even in a case where somebody can't actually be returned under 8.1c. In other words, the appeal right under 841E allows the applicant to argue that the decision is not in accordance with the law. That includes in accordance with the Immigration Acts, specifically paragraph 8.1c, and in accordance with general public law. Both the Immigration Acts and general public law, in my respectful submission, require the decision maker clearly to at least take into consideration whether or not a person can be removed under 8.1c to one of those countries or territories.
Well, I mean, the trouble is that it might be something that could be considered at various levels. A decision that someone be removed from the UK by way of directions under paragraph 8 could mean a decision, I decide to remove you by way of directions which I believe and actually propose to give. I may be quite wrong, but it's still a valid decision. And if at a later stage I give the directions, then they may be challengeable. So I think, I'm not sure it answers the question to say that to some extent the directions must relate to a particular country. It could be sufficient if they just relate their bona fide proposal.
Of course, I accept that, but then the bona fides of that proposal are part of the decision.
Yes, but you're not
and it's
challenging, I think, the bona fides of the Secretary of State's proposal here. I mean, he's put it forward, and he's certainly arguing that it's something he intends seriously to consider.
Yeah. Though it's not quite bona fides under the legislation, is it? It's whether he has reason to believe.
Well,
and then
that's at a later stage. That's when he actually makes the removal directions. That's the test then. At the moment, I'm suggesting that it might be quite sufficient for him to say, I've identified a country, I accept there are some detailed consequences in the human rights and refugee field, but otherwise it's just sufficient that I've identified it. And I believe, or I propose genuinely, this is the country.
Well, the question then is whether that type of proposal is sufficiently concrete to amount to the type of decision referred to in 82(2)H.
Yes, your reading in has got to be a proposal which has some realistic, reasonable prospects of success now.
Well, I only submit that the decision has to be a decision that follows the language of para 81C in a para 81C case, going back to divider 1 of volume 1, page 39. So the Secretary of State, in order to make a decision that a person is to be removed under paragraphs 8 to 10, needs to have reason to believe that the person about whom the decision is made will be admitted in the future to a particular country or territory. That's a very low threshold, which, as I've previously accepted. But if the person concerned is able to demonstrate that it is impossible, that there is no reason to believe that they will be admitted in the future to that particular country or territory, then axiomatically, in my submission, the decision won't be in accordance with paragraph 81C, which only entitles the Secretary of State to make a decision to give removal directions to a country or territory where there's reason to believe a person will be admitted, and it will also be an irrational decision. When I'm conscious of the time, I'm also conscious of the fact that I had some submissions to make about the breadth of the appeal right under 84(1)E and about the one-stop provisions under section 120. And in particular, there have been a number of cases in the Court of Appeal about the one-stop provisions under section 120, which really underline the importance of those provisions as a driver for getting many issues before the appeal tribunal, including issues which, on one view, one wouldn't necessarily consider as being part of the immigration decision if one wasn't viewing the question in the light of section 120. I am very much in the court's hands. I can give the court the references to the cases and then sit down and let Mr. Iker have a go.
How does Section 120 cast light on the meaning of immigration decision?
Well, the choice is between a relatively broad or a relatively narrow approach to the construction of 82.2h and to the scope of the appeal under 84.1e. And what the cases indicate is that Section 120 and related provisions in the 2002 Act show that there is a strong public policy or a strong purpose underlying the 2002 Act to ensure that as many relevant issues as possible are dealt with in the appeal process and not later on. It can't change the meaning of Section 182.2h if that provision has a clear meaning. But if a broader or a narrower construction is possible, then these cases and Section 120 indicate that one should go for the broader construction.
But isn't it talking about attempting to stop the practice of successive appeals? The question we have is what is the scope of an appeal? Not whether if the scope of the appeal is such and such, then Section 120 doesn't apply. Clearly, Section 20 does apply, and you have got to advance all your grounds of appeal in one go, unless you've got good reason for not doing so. But I don't, at the moment, see how that really helps in deciding whether something is the subject matter is as a matter of statutory construction a subject matter of an appeal or not.
Well, I respectfully can see the force in that, although in fact if one looks at the cases, that is precisely what the Court of Appeal has done on a number of occasions. They've used Section 120 to construe the appeal rights considerably more broadly than they otherwise might have done. One of the cases is the case of JM Liberia, which is at tab, it's volume 3 of the authorities' volumes, and it's tab 34.
Tab, sorry.
It's tab 34.
Thank you.
If one starts at paragraph 14, the Secretary of State made a decision under Section 82.2d, which is a refusal to vary a person's leave to enter or remain in the UK, if the result of the refusal is that the person has no need to enter or remain. And then the appeal over the page was brought under 82.1g.
That's not an accurate transcription, is it?
I'm sorry, my lady, at 82, I'm looking at paragraph 14.
Paragraph 14, 82.2d
Yes.
is not accurately transcribed. If the result of the refusal is that the person has no need, need should be leave.
Yes. Thank you. It's leave. The ground of appeal was 82.1g over the page, removal of the appellant from the UK in consequence of the decision would breach obligations under the Refugee Convention. And then Lord Justice Laws said there are other statutory provisions to which I'll refer, Evidently, the court has to decide whether an immigration decision consisting in a refusal to vary leave, which is appealed under 82(2)d, is an immigration decision in consequence of which the appellant's removal would be unlawful under the 1998 Act. The answer to the question must, I think, depend on the sense Parliament intended to give the phrase "in consequence of." In a case where variation of leave has been refused, removal is not an immediate consequence. Removal directions must secondly be given if the appellant is to be removed under the present statutory regime. Directions can't be given contemporaneously with the refusal to vary leave, but refusal may at least be an indirect consequence of the refusal to vary. Did Parliament, in enacting 84(1)g, intend this latter wider sense of consequence, or only the narrower sense so that it referred to an imminent removal? There were a range of considerations that the Court of Appeal looked at before deciding that Parliament intended 84(1)g to have the wider meaning. One of those considerations was the one-step appeals machinery, which is identified at paragraph 23. There is perhaps an even stronger decision in the case of AS Afghanistan, which was quite close to the borderline, and in fact there's a very thoughtful dissenting judgment by Lady Justice Arden, who defines the issue in paragraph 1.
Sorry, where have we gone?
This is tab 27, volume 3. In paragraph 1 of her dissenting judgment, about 4 lines down from the top, she says the appellants say that the effect of a one-stop notice is that the appeal covers not only any ground before the Secretary of State when he made the decision under appeal, but also any grounds raised in response to a one-stop notice, even if they had not been the subject of any decision by the Secretary of State, and does not relate to the decision under appeal. This is the wider interpretation of the relevant provisions. The Secretary of State contends that one-stop notices have a far narrower effect on appeals. His case is that the only grounds that can be put in issue on appeal are grounds placed before the Secretary of State when he made his decision, or grounds raised in answer to a one-stop notice which relate to that decision. That's the narrower interpretation.
Sorry, which paragraph were we reading then?
That's paragraph 1.
Oh, paragraph 1.
That's paragraph 1, starting about 4 lines down. That's where Lady Justice Arden defines the issue.
I can't remember what we did with this case. I know it's been the subject of an application for permission to appeal, because I remember reading this judgment then.
I understand from my learned friends that it's been refused.
That's what I thought, but I was reluctant to trust to my memory.
I'm
I'm not
su-
sure that affects your argument, but
No, I mean, the majority decided that Section 120 required the wider approach to be taken, although I'm not sure that the effect of a refusal of permission to appeal in any sense puts the approval of this court on the decision,
I
necessarily.
I don't think it does.
No.
Wasn't necessarily suggesting the decision.
It's paragraph 78 to 81, and then paragraph 84 is Lord Justice Morbick, who was in the majority, explaining why, in the view of the majority, the policy underlying section 120 was so strong as to require a broader construction. And specifically on the role of judicial review in immigration cases, one has the case of G against the Immigration Appeal Tribunal, which is in volume, I'll try and take this fairly swiftly. This is in volume 4, and it's tab 43. And it was an attempt to bring judicial review proceedings after the refusal of an application for permission to appeal to the Immigration Appeal Tribunal, and after the dismissal of the High Court, the dismissal of an application for a statutory review to the High Court. And one can probably go straight to paragraph 15. Where the Court of Appeal gives its reasons for excluding the possibility of judicial review in the context of, in this particular context, but making it clear that one of the purposes of the 2002 Act was to reduce the scope for judicial review of immigration decisions so as to promote speed and certainty.
It's another in which we refused leave to appeal.
Sorry?
It's another in which we refused leave to appeal. For what it's worth.
I'll try and draw the threads of all of this together. If I may just say something about the appeal rights under 84(1)(e. I mean, in general, rights of appeal are construed broadly for a number of reasons. My authority for that is the Nipa-Begum case. I just give the reference for the court's notes. It's in volume 4, divider 40, and it's 312 capital G to 314 capital H. The importance of, in this particular context, of a broad right of appeal to the tribunal is shown by a number of points. Firstly, the broader the appeal right is, and the broader the immigration decision is, the more delays and the possibility of further litigation ought to be reduced. Because all the issues, including all the paragraph 81C issues, are determined at an early stage. Tribunal proceedings clearly are significantly cheaper than administrative court proceedings. There are no fees in the tribunal, but the administrative court fees are quite high. It's £50 to apply for permission, £180 for judicial review, £75 for interlocutory applications. They're not huge sums, but this is a high volume jurisdiction. Lawyers get paid, publicly funded lawyers get paid significantly less in the tribunal. Thirdly, the tribunal, unlike the administrative court, is a specialist body. And although formally, of course, it is a court, it is an extension of the administrative decision-making process. Fourthly, as the court will be aware, see section 85, unlike the administrative court, the tribunal has got full power to examine the facts underlying the Secretary of State's decision. Fifth, the tribunal is more flexible, more informal, it's inquisitorial. Six, there is an appeal on points of law from the tribunal to the upper tribunal, which is the superior court of record, which further relieves pressure on the admin court, the Court of Appeal. Seventh, the tribunal can give directions to give effect to its decision where it allows an appeal under section 86. Seventh, matter of long-standing public policy, judicial review is an avenue of last resort. And finally, the essential question that the appellant sought to raise in his appeal before the tribunal was whether or not there was reason to believe he would be admitted in the future to Palestine. That question is eminently the sort of question that a specialist tribunal with power to examine the facts ought to be deciding at an early stage, rather than the administrative court months or perhaps years later on down the line. Those general considerations about the desirability of construing appeal rights broadly and allowing the tribunal to take the strain away from the administrative court and the Court of Appeal are underlined by the one-stop provisions and the general policy of the 2002 Act to require all issues as much as possible to be focused before the tribunal and to be dealt with as far as can be done once and for all. And it makes, in my respectful submission, obvious sense for the tribunal to get to the bottom of whether or not there is actually any reason to believe that a person will be removed to a particular country or territory. In my respectful submission, it is really impossible to abstract the decision about which country a person is to be removed to from the decision-making process referred to in section 82(2)(h). Firstly, axiomatically, though we haven't looked at the rules and policies, axiomatically, even in a non-refugee convention and a non-human rights convention case, the decision-maker, before he decides whether it's appropriate to exercise his discretion to remove somebody from the jurisdiction, of course has to consider where that person will be removed to and whether it's appropriate to remove the person to a particular country or territory. It's looking at the general considerations that the decision maker will have to engage with. When the decision is made under section 82.2h, by the terms of 82.2h, the decision maker is required to have regard at least to the machinery under paragraphs 8 to 10. The machinery under paragraphs 8 to 10 specifically require consideration to be given to whether there's reason to believe in a paragraph 8 C14 case that a person will be admitted to the country or territory. And the notices regulations make it crystal clear that that part of the decision is an integral part of the appealable immigration decision. So for all those reasons, whether one looks at it from the point of view of the breadth of the immigration decision under section 82.2h or the breadth of the appeal rights, one comes to the same conclusion in my respectful submission. If I may just turn to my side and behind to see if I've missed something out. Unless I can assist the court any further, those are my submissions.
Thank you very much. Mr. Sid? Yes, Mr. Eichen.
My lord, my lady, I'm very conscious of the time, so I'm not sure how the court wishes to deal with the rest of today. I had understood that the court wishes to rise at 4, but I'm content to go as long as the court will let me. But thought I'd raise it before I start.
Probably depends what you're saying to us.
My lord, I will start and then be told.
You have 5 minutes in which to make 5 excellent points, if you have them.
My lady,
Send us away with them ringing in our ears.
My lady, I fear I may have to admit defeat right now, but I will start, if I may, start with.
It is set for a day and a half. I see what you mean.
If I may, perhaps start with perhaps a short point on the notices regulations before I move to the statute, and that is in volume 2. At tab 18, and really to clarify one aspect of my learned friend's submissions, who, as I understood him, indicated that under the regulations, why there is a duty to state reasons in relation to some decisions, namely the decision under paragraph 4.1, there's no duty to state reasons in relation to decisions under paragraphs 4.2 and 4.2a. And just to correct that, of course, paragraphs 5.2 and 5.2a make quite clear that the duty to state reasons in relation to those decisions, and in particular in the statement into the decision of the rejection of the claim for asylum or the decision that the person is no longer a refugee, is also one that is required to be in the notice. The second point I wish to make relates to 5.1, to paragraph 5.1, which we do submit focuses on the content of the notice, certainly in relation to the country, rather than the content of the decision. And in our respectful submission, that is, of course, also supported by the case law my learned friend took your lordships to, and your ladyship to, all of which relates to section 84.1g, which in its terms talks about removal in consequence of the immigration decision, rather than of the immigration decision itself. And in my respectful submission, in practical terms, that makes eminent sense, because if, as my learned friend had submitted at the closing of his submissions, the decision were made at the beginning, one just needs to take this case. This case has now been about 2 years in the appellate process, and a lot can happen in 2 years. So the decision would have to be retaken, even as a matter of fact, in order to investigate the situation in the country to which removal was due or was proposed. If I could then ask your Lordships and your Ladyship to turn to the 1971 Act, which is Volume 1, Tab 1. And your Lordships and your Ladyship have seen the definition of illegal entrant at section 33 at page 31. If I could then turn again to paragraph 8, 9 and 10, and in a sense just to put them in their context. In our respectful submission, it's important to note that paragraph 8, in our respectful submission, paragraph 8.1 before the A has two components. One is it requires that the Secretary of State or an immigration officer has made a decision in relation to a person arriving that he or she is refused leave to enter. Only once that decision is made does the second component arise, the second component being the power to make removal directions. It's not the actual removal directions, it's the power to make removal directions. An immigration officer may, and then we get into A, B, and C. That's, of course, the first of the three provisions referred to in 82.2h, but the one that really is relevant in this case is 9. Paragraph 9, again, requires a number of components to be fulfilled, which arise in the context, which we see in the context of this case. The first is that the individual is an illegal entrant. And as was made clear in the House of Lords decision in Khawaja at page 100A, capital A, that's volume 4, tab 44, the decision whether an individual is an illegal entrant or not is a discretionary decision to be made by the immigration officer. There's then a second requirement, which we saw fulfilled in this case, namely that the identification of a person as an illegal entrant is recorded in a decision contained in a notice IS 151A, namely a notice of illegal entry, which we see in this case at page 37 of the appendix, and that was issued on the 25th of April 2007. So tomorrow, exactly 2 years ago. It then requires a third...
Sorry, where do we see that in paragraph 9?
So paragraph 9, my Lord, that's not expressed. I should perhaps have been clearer. It is implicit in the reference to where an illegal entrant is not given leave to enter. In order to get to the consideration of leave to enter, two decisions have to be taken. One is the decision that an individual is an illegal entrant, and that is contained in, is a discretionary decision described as such by the House of Lords in Khawaja. Secondly, to issue a notice of illegal entry, which the High Court considered a separate discretionary decision in the case of Uluyol and Kakmak against the immigration officer, which the court has at volume 5, tab 57. And as a result of that judgment, that is now also recorded in the enforcement guidance of the Secretary of State, which your Lordships also have, and your Ladyship, at tab 7, volume 7, tab 76. In Uluyol, the relevant paragraphs is paragraphs 34 and 35, and then the conclusions at 40 and 41. And your Lordships and your Ladyship will see that this was then accepted by the Secretary of State and transposed into Chapter 7 of his guidance, which is at volume 7, tab 76.
Seems to me a very odd situation. Somebody's an illegal entrant, but you have a discretion whether to treat them as an illegal entrant. I can see you have a discretion whether to detain them. On the face of it, page 37, that IS 151A notices exercising that discretion.
My lord, yes, but...
Why do you have to have this rather curious? What is the effect of not exercising the discretion to treat them as illegal entrants?
My lord, if in practice, as I understand it, if no IS 151A is issued, i.e. there's no notice of illegal entry, which is the decision the court was concerned with in this case, then none of the subsequent consequences can flow. So no decision under 82.2h can be made, because no removal can take place, because the person has not been told and has not been notified that he or she is an illegal entrant, which is a mandatory requirement for paragraph 9 of Schedule 1 to the Schedule 2 to the 1971 Act to operate.
Well,
Well, you can tell us tomorrow what the source of that mandatory requirement is.
My lady, I will try my best.
10:30, please.
Certainly.